Did recent Supreme Court terms see many writs of certiorari granted? Imagine a courtroom where the number of cases accepted can shape the legal landscape for years to come. The Supreme Court of the United States plays a pivotal role in this process by deciding which cases to hear through a procedure called granting writs of certiorari. These writs are requests for the court to review decisions made by lower courts. The frequency with which these writs are granted can indicate the court's current focus and the complexity of legal issues facing the nation. In recent years, the court has seen fluctuations in the number of writs of certiorari granted. Typically, the court receives thousands of petitions each term, often exceeding 5,000. However, only a small percentage of these petitions are granted. For example, during the term starting in October of 2022, the court granted approximately 1,350 cases out of over 5,000 petitions. This grants rate of roughly 25% reflects a selective process aimed at addressing the most significant legal questions. The trend over recent terms shows a slight decrease in the total number of writs granted compared to earlier years. For instance, in the term starting in October of 2021, the court granted around 1,000 cases, which was a slight decline from previous terms. This reduction may be due to various factors, including the court's strategic priorities, the complexity of cases, or the availability of cases that meet the court's criteria for review. It is also noteworthy that the court has been more selective in recent terms, focusing on cases involving constitutional issues, federal questions, or conflicts among lower courts. This selectivity ensures that the court's limited docket addresses the most pressing and impactful legal questions. In summary, recent Supreme Court terms have seen a moderate number of writs of certiorari granted, with a trend toward greater selectivity. While the overall number of cases granted each term remains relatively stable, the court's approach indicates a careful consideration of which legal issues warrant its attention. This pattern underscores the court's role as a gatekeeper for the most consequential legal disputes in the country.